All right, Bill Henshaw here again, Constitutional Kook headquarters. With more and more good news just continuing to roll in for us, including me personally, since I've now apparently been permanently removed by YouTube, without any notice or opportunity to be heard after apparently only one strike on their allegedly applicable administrative procedure, which who the hell knows what that is. And with in effect, what they've done is to prevent the jury will rule as a recognized legal expert, giving expert witness testimony on the Constitution, history, and laws of the United States. And yet, YouTube calls that, menace to public safety, or however you want to phrase it. But it's hard for me to see we're telling the truth to the American people in a venue in which I may be one of the very few that's actually doing that is a problem at all. What's the true agenda here? Oh, I'd love to hear it, especially in front of a jury, which isn't going to happen. And one reason for that, by the way, is documents. I edited one and created another one in my trial court packet that are killers, because one of them is a notice of disqualification of each and every one of these state bar association attorneys. And you have to be one out here where I am in California to even be able to run for a position of judge, let alone get elected. And of course, you have to have a license to practice law to go into their courts and plead all the BS civil rights issues they do. And this is likely true across the country. I don't know at the moment of a jurisdiction where it's not true, but that wasn't so in an earlier era. And it should not be true now, particularly since we have the right of unlimited power of contract secured by Article 1, Section 10 of the Constitution for the United States, if not the 9th and 10th Amendments thereof, which do apply to the states, not the Bill of Rights, like I told them in South Carolina in the first 30 seconds of my initial appearance there. I stunned the whole courtroom into silence when they, asked me or read me the charge with practicing law without a license, and I laughed. And I'm there, manacled hand and foot in the red jail suit. I laughed and said, the problem with that is I don't practice it. I get it right the first time. And then the judge goes on and says, well, we have to be sure you're quote unquote competent to represent yourself. If I could have thrown up my hands, I would have. And I said, oh, bark that Beretta v. California, 422 U.S. 806, Judge. The problem with that is the U.S. Supreme Court has ruled the Bill of Rights does not apply to the states. Stunned the courtroom into silence from which they never recovered. That's the power we have, and it's what I want to teach you how to study, learn, and get. And you won't have to put anywhere near the 10,000 hours I did in those musty old stacks of law books. So send me an email about that, unincourt@gmail.com, and I'll send you my updated version, of that disqualified document and some other bonus documents when you ask for information. I mean, these are killers because it disqualifies every one of them. And this, people, it's an act that really these black robe bastard judges should be doing what's called legally sua sponte, on their own motion. When we walk in there, and we're clearly not to be confused with Chase Bank, IBM, Microsoft, or any other corporate entity. These judges, quote unquote, that have a sworn duty to be bound by this Constitution and the laws enacted in pursuant thereof, have the sworn duty, don't they, to dismiss when they realize we're not a corporation and the statute doesn't apply to us. Simple. Why doesn't it happen? You'll learn more about that too. Send me an email, unincourt@gmail.com. I mean, it's just been astounding what's been going on lately. And as I mentioned in earlier tapes, one of which was totally removed by YouTube within 30 minutes on the grounds of medical misinformation, where I playfully made a reference in about the first 20 seconds to the COVID pandemic, which is exactly what it is. But the rest of the tape, which is 11 or 12 minutes, I offered expert witness testimony on the decision of the Fifth Circuit Court of Appeals summarily striking down the mandatory OSHA vaccination. And they've, by the way, already backed down. OSHA has, and I don't know where they're going to go from here. Because if it gets reviewed by the Supreme Court, and no reason to do it, because the way they wrote this opinion, send me an email, youwinnincourt@gmail.com. I'll get you the opinion and the highlights from it, which sounds exactly like me. That's stunning. Because the court said, in effect, it's beyond the Commerce Clause powers of OSHA, most definitely, to do this. And it would be a hard question to determine whether Congress had it or not. And if the courts are finally ready to go there, I have a cappella information off the top of my head to address that issue. Either in front of a jury, or if it's oral argument with the 9 parts, or you name it. Right up my alley. That's what 5 decades of relentless, intense, passionate, and independent study will do for you. Now, you don't have to do that. A lot easier for you. Send me an email, youwinnincourt@gmail.com. I'll get you information on my documents, and you are going to have some work to do. I'm not telling you it's going to be easy, but you start raising the issues that I present, all of them unopposed, all of them dead, bang, black and white, when you understand the truth about, the Constitution, laws, and history of the United States over the course of the last 230 years. And that's what the Wall Street banksters don't want you to know. They, get by with all this divide and conquer racist bullshit that has to stop. If we're going to beat them, we all have to do it together, all pull together with the same issues, same courts, and basically same standing, and get used to it for the moment of the sovereign body politic of the nation and republic. What is it? Free, white, male, 21. That's it. That doesn't mean that nobody else has enforceable rights, however. As you look at the Northwest Ordinance of 1787, is reenacted by the first Congress, and inhabitants of territories have the right to trial by jury according to the course of the common law and habeas corpus. And you try and find those things today available in any court. And this now apparently includes the 9 parts in my hometown of Washington, D.C., where you can't even get documents filed. Those of you that have seen my videos with Adam talking about his document, and it's the best pleading I've ever seen that's gone there, 166 pages, and the clerk refused to file it. The justices never saw it. How the hell is that possible? And that's what we're working on here. There's good reasons for it. You'll learn a lot more about that. Send me an email, youwinnincourt@gmail.com, and I'll get you up to speed in a lot of different areas. Like I said, it will take a little time, and I was a slow learner. I didn't get it right away either. When I did, and it all hit home, my goodness, and this is what should happen, by the way, in high school, 10th, 11th, and 12th grades, if they teach this stuff and wake you up like they're supposed to be doing in the mandatory public education system. Didn't hear it there. In this day and age, with mostly, both parents out working to support the family and this, that, and the other, you don't get a lot at home. Although parents these days, their parents and the parents before them didn't know a hell of a lot either. My grandmother did. I have a hand-me-down couple of textbooks from her, Swinton's and Appleton's, I think. And in those books, this is at the end of the 19th century, there was a lot of it still in these books because it was relatively current, and it would have been very difficult to explain away to people that knew a lot about what was going on. So that's where these older books are valuable resources. And even some later ones, and I'll be talking more about that later. But you learn the truth here, what really is going on. And it's stunning how much sense it makes. And a lot of you instinctively understand there's a lot wrong with the system. It's my job to get you up to speed as to how to do something about it. Send me an email, youwinnincourt@gmail.com. We'll get down to business here. I can help you across the board. Doesn't matter whether it's, criminal, IRS, family law, which is one of the worst, or whatever it is, mortgage loans. Mortgage loans don't exist. The mortgage lender doesn't exist. And the dollars are undefined. You start raising issues like this and see what happens. They're going to run for the hills, which is the power we have. Because in those mortgage agreements and student loans and whatever, like that, they didn't bother to tell you all the terms and conditions of the contract that you signed into. And again, this is in an era where you don't learn anything in school and can't reasonably be expected to know it. And that, people, is an affirmative defense in any common law court exercising judicial power of the state admitted into this union. So the power we have is we go in there with these issues, even in our own case. The danger for them is if they get out there and the public becomes aware of them, that's bad enough. If the jury comes aware of them, that's devastating. And if the 904s rule on our issues, there's only one way they'll be able to rule on them in our favor, since they won't be opposed. It undoes every mortgage from Portland, Maine to Portland, Oregon. See you later. That's what should be happening, and we can get there. So to that end, send me an email, youwinincourt@gmail.com. I will get you up to speed on all this. You're going to love it. And what's it done for me, you can see. And I wish I had that videotape from South Carolina where I shut the badgers up in 30 seconds. It's stunning. They claim not to have made it, by the way, this in a court of record. But it's the kind of power we have, and it's why in my 74th year, life is still ahead of me. That's amazing. We got people here 20, 25 years younger than me that don't feel like that because they've never learned that that's how they're supposed to feel. That's what they don't want you to know in the boardrooms of the New York banksters. Once you know that we have rights and we have enforceable rights, and they don't have any standing in our judicial courts, that's one hell of a turnaround. And this in the only nation in which was ordained and established in which that's possible. And we have the framers to thank for that. I don't care how many of those framers were racist, quote unquote. They're saying Jefferson was now in Washington, because I'm sitting here waiting for the Jefferson Memorial to come down in Washington, D.C. I mean, this crap has to stop. Divide and conquer, that's all they know. Let's work together and prevent that from working, especially if they get before a jury. And that's where we beat the bastards, because they can't have us going in there unfettered by a state bar association attorney to raise some real issues in front of the jury and instruct them as to what they're doing and wake them up. To the fact they have the power to rule on the facts and the law. We're going all the way back to the Magna Carta in 1215. The framers knew that very well. It was well known for most of the 19th century, and yet somehow it's gotten away from us. If we get that one thing back, and we either get it back or it's dead bang proof that there are no states remaining which were admitted into this union, and that there's no government because they're not represented anywhere in there, and neither is anybody else out there except corporations. My goodness, don't let anybody tell you any different. Especially Al Sharpton and Jesse Jacks. Civil rights didn't worth the powder to blow it to hell. 14th Amendment has never existed. Never. Supreme Court ruled it contemporaneously unconstitutional. You can learn all about that. Send me an email, youwinincourt@gmail.com. It blows the cover off the whole operation. And in what looks like an unprecedented window of opportunity where we may be able to make changes, make our lives better, our children's lives better, and our posterity's lives better. That's what I've been put here to do. I don't know how that happened, but it's the job I was put here to do. It would have been great if I had known that 50 years ago in high school, but better late than never. And the same for you, better late than never. You can get in there and start doing the same things, because they have nowhere to run and hide. With these recent document changes I've done here, disqualifies all of these state bars, people that are in positions of honor, profit, and trust in the de facto government. So you have no judges that can make any rulings, which they can't do with our issues anyway. You have nobody in the office of the local dumbass who can even file charges. I mean, it just goes on and on and on, and it all makes sense. Instinctively, most of you know that's out there. You just don't know the whys. That's my job. send me an email, youwinincourt@gmail.com. We'll get down to business. That said, remember to subscribe, like the videos, tell your friends, get the word out. The sooner we all work together, the quicker we get these bastards off our